Hello everyone, today is August 4th, 2026. We are here again on a Tuesday at 2 p.m. every week, same time. Welcome,
yes.
Leila.
Thank you so much.
So as we have done previously, we will start talking about the immigration law developments from last week, and then we will start answering your questions. Before we get started, we kindly request that if you want to ask a question through this chat, you need to subscribe to the channel. That way you will be able to type your question to the chat. And we are live on TikTok, YouTube, Instagram, and Facebook today. But the questions can only be asked through YouTube and Facebook. We cannot accept questions from either Instagram or TikTok because of technical restraints. But if you have any questions and if you are watching us from TikTok or Instagram, you can just come to Immigration Champion channel and ask your question through there. So Leila, what do we have this week? Did you notice anything unusual regarding immigration?
Yes, as we touched upon last week, we were talking about how TSA and ICE are now coordinating and people are being detained at airports, domestic flights, people taking domestic flights, even the people that have an employment authorization card or a application pending are now being detained. American Immigration Lawyers Association has confirmed that the two agencies are coordinating, and I believe there's been an uptick in the number of people that are being detained.
Yes, so this is really concerning, even though these people came with a visa.
Yes.
But if they overstayed or if they have any pending applications, they can still get detained.
Yes, the concerning part is most of them filed for some application before their status expired, and some even have employment authorization cards through the application that they filed for, but they're still being detained because their underlying status has expired and they're in a pending status right now.
I see. So let's say someone came here with a tourist visa and then they filed for green card, let's say based on marriage.
Yes.
And then they no longer have the tourist visa status.
Correct.
And then they only are staying here with a pending green card application.
Correct.
But if they travel domestically, and then they can get detained.
Yes, even if they're married to a U.S. citizen, they're being detained.
Yes, this is really concerning. So what do we know about the TSA and ICE coordination? In the past, they did not coordinate or they did not pass information to each other?
That's my understanding, that in the past this was not happening. And usually people that have a pending case are considered to be in some sort of like gray status area. Under the color of law, they're protected. And therefore they were not being detained. This is very surprising that now they're being detained.
Yes, so we do not recommend anyone traveling domestically if they have a pending affirmative asylum application, if they have a pending defensive asylum application, or if they have a pending green card application, if their current status, if their previous non-immigrant visa status has expired.
Correct.
How about like the employment-based status extensions and other stuff? Did you see any, did you hear anything about those people?
I believe Ayla was reporting that non-immigrants that have H-1B status that have an extension pending, if their previous status has already expired, they have been detained as well.
Oh, that is really concerning. Yes. Okay. All right. Do we have anything else this week to talk?
Well, we can talk about the TPS. We know that on July 27, 2026, the TPS for Haiti and Syria was not extended. So therefore, over 300,000 people suddenly are now undocumented and may be targeted and detained by ICE. That's a big concern. Another concern is that most of those people already had an EAD based on their TPS, so they were employed. A lot of employers lost their employees in a matter of a night, and that also impacts the employers as well.
Yes, I even received emails from E-Verify saying that like many TPS for many countries now deactivated, and employers might have to let their employees go.
Yes.
And it is very interesting that I was talking to one of my clients who is detained in Adams County Detention Center for about 21 months now. And he was saying that in the past few months, the detention center's capacity was low, and they closed a few buildings. I believe there were 7 buildings, and they closed maybe 2 or 3 of them. But now they are overcrowded after this TPS decision, and they are detaining many people who had previously TPS protections.
Yeah, my understanding is that ICE has a quota as to the number of people that they have to arrest. So I believe they're just trying to meet their quotas.
Definitely.
Yeah.
I also want to mention that last week someone reached out to me at the weekend saying that they have a last-minute appointment with ICE. They received a letter on Friday asking for them to report on Monday for ICE check-in. That person specifically came through the southern border and applied for asylum inside the US. And I told him that it is very likely that he will be detained at that check-in. And indeed, he was detained on that day, but we were prepared, and we filed our habeas corpus petition on the exact same day. And even in less than 24 hours, we got an order from a federal court judge saying that this person must be immediately released. Wow. It was amazing decision for us, and then there was no bond hearing at all. Amazing. And our client was so he and his family were so happy. So my recommendation is that if you are scared of getting detained, yes, you should talk to an immigration lawyer, and maybe give the immigration lawyer your documents. And then in case, God forbid, something happens to you, someone else from your family or friends can reach out to that lawyer, and they can file a habeas corpus petition right away. Because if you wait, ICE might transfer you to another state. Mm-hmm. It can be a state like Texas or Louisiana, and habeas corpus petitions are less likely to be successful in those jurisdictions. So if yes, you are in a state where maybe in the East Coast, you should be very fast filing that lawsuit. So that is my recommendation for the people who are scared of getting detained.
I actually had heard about a case where somebody from Long Island was detained, and she was quickly moved to 3-4 different states. So even her family had a difficult time trying to locate her, and it was really quick. So
yes, and ICE has a website called ICE Detainee Locator. However, in the first 24 hours, they do not update that website, so you cannot see where your loved one is currently detained at. So that is really concerning as well. Another topic you were mentioning just before we get started is that the bond issue.
Yes.
What is that? Can you talk about that?
Yes. So basically now for 50 countries, majority African countries, they are imposing a bond if you're applying for a B1, B2 visa. The minimum amount is $10,000, and based on the officer's decision, it could go up to $20,000. As I said, it's majority for African countries and some other countries such as Nepal, Tajikistan, Turkmenistan, Georgia. Based on what I have heard, it's based on the number of overstays from those countries. So if the country has a lot of people that came to the U.S. and overstayed, now a bond is required. So to kind of try to enforce the fact that when before your I-94 expires, you leave the U.S., otherwise you forfeit the bond. Okay,
so let's think about this. If I am a Turkmen national, let's say, and then if I if I want to apply for a tourist visa and for myself, for my spouse, and for my 2 children, to have a vacation and maybe to visit Disneyland or Disney World. When I do the budget for that travel or vacation, then I need to calculate bonds just for visa to be able to apply for visa.
Correct.
And even if I am approved, I need to pay US government. So this is just per visa, right? So per family member.
My understanding is that it's per family member and it's effective starting yesterday. And there's an additional form that needs to be completed as part of the visa process.
Yes, everything is getting harder.
Yes.
All right. Do you have anything else for today?
Well, I want to say last week, as compared to the weeks before, it has been less changes in the immigration world. I don't know if that's good or bad, but
yes,
less changes.
Then let's end with a good note that I made an amazing call today in the morning. I called my client to tell him that his long pending I-485 green card application was approved only a week after we filed the Mandamus lawsuit. It was amazing. He has filed his green card application with a different attorney, with a different immigration attorney. And he reached out to us saying that I heard about you and you are experienced in federal court matters such as Mandamus lawsuits. And I believe that my application has been pending for unreasonable amount of time. Even the case processing times website shows maybe 11 months and his was 12 months. So we filed the Mandamus lawsuit, and right after we filed the lawsuit, a federal court judge issued an order saying that the government has only 7 days to respond to this lawsuit. And shortly after that, we reached out to the U.S. Attorney's Office because we have contacts there. We file lawsuits and we work with them all the time. And they were nice enough to coordinate with USCIS, and they were able to get this application, both I-130 and I-485 approved without an interview. Did you?
Wow, that's amazing.
Yes. Did you recently hear any green card case, marriage-based green card case approved without an interview? No. I don't think so, right?
No, not recently.
So Mandamus lawsuits are going very well. I think even under this administration, if someone's case has been pending for a long time, they should definitely think about this lawsuit. All right, I think we have a few questions, but I want to start with the one we received prior to the live. So this person is asking why F4 petitions not running forward since a long time when it will run forward. What do we know about F4 petitions, I-130 family petitions?
So F4 petitions generally for siblings of U.S. citizens. And basically that visa category is really backlogged. There's a lot of requests and very little visa numbers allocated to that category. It's the lowest percentage of visa numbers allocated in the family-based immigration. And there's a big backlog, especially for India, Mexico, and Philippines. So that's the reason why we really don't see a lot of movement, because of the number of visa numbers available. I believe it's only 7% maybe of the visa numbers available are allocated to that category.
Yes, so I always say that file and forget.
Yes, exactly.
Because it is very likely be much more helpful for the beneficiaries' children than the beneficiary themselves, because I believe there is 17 or 18 years of waiting period for rest of the world.
Yes.
For Indians or Chinese, maybe it's longer
Yes.
period. And yes, so someone reached out to me saying that, my sibling filed the petition in 2011, and I checked the visa bulletin, but it was still not current, even 15 years after the I-130 filing date. So just be patient and try to, if you want to immigrate earlier, try to look for other options, I guess.
I mean, I've had clients that have reached out to me, and once they know about the visa bulletin, some of them get discouraged. But what I always advise to my clients is that whether you file it or not, the time is going to go by, right? So
definitely. And it is not that much expensive.
Yes.
Like, to be honest, it's just $625. Even for tourist visa bonds, they have to pay now $10,000 to $20,000. So I think it can be done.
I think that thinking that it's so far ahead in the future discourages them. But whether you file the case or not, the years are going to go by.
Yes.
So at the end of the day, you might be able to obtain a green card.
Definitely.
So
Why
it's
not?
worth it. Yes.
All right. So let's switch to the questions asked during this live. Bad Guy says, got my green card in 2018, briefly visited the US in May 2022, and moved permanently in September 2022. Can I apply in February 2027 using 90-day rule? So I think they're asking for naturalization citizenship application.
That's what I believe too.
So I always recommend that, because the N400 naturalization form asks for the travels outside of the US only for the past 5 years, right?
Yes.
And it asks for the nights spent outside the US. So if a travel has started earlier than that time, and I generally prefer to wait until that travel is completely wiped off, so that during the past 5 years you only have travels shorter than 180 days, and in total you have spent more than half of the 5 years before you apply for citizenship as a physical presence rule.
Correct.
So if they have entered September 2022,
I would definitely wait until September of 2027, even though since this person has been a permanent resident by that time, more than 5 years, he's entitled to the 4 years 1 day rule, which means he only has to go back 4 years and 1 day to be eligible after he entered the US.
Can you expand on that?
Sure. So in this case, he said he received his green card in 2018. So by 2027, it'll be 7 years that he's technically a green card holder. And as a green card holder, you can use
2018, right? So
yes.
By 2027, 9 years.
9 years, yes.
Yes.
9 years, yes. So basically, he is entitled to use the 4 years and 1 day physical presence rule. So he can, from May 2022, he should count 4 years and 1 day. And if he's had more than 30 months of presence in the US without leaving the US more than 6 months, he's entitled to file 4 years and 1 day. But if he does not have a re-entry permit for the time frame that he was outside of the U.S. from 2018 to 2022, I would not suggest that, because they can argue that he has abandoned his residency.
Definitely. So even with re-entry permit, I am still concerned. Maybe I am overly cautious. What do you think?
I mean, I've done it in the past with people who have had a re-entry permit, because the argument is that I went about it the right way. We did receive RFE, but we did respond to the RFE that this is the purpose of a re-entry permit, that I'm asking for permission to stay outside. So I have therefore not abandoned my residency, and I have used the 4 years and 1 day rule, and it's been successful. But in this case, if this person has not applied for a re-entry permit, has stayed outside the US, maybe even more than a year, definitely I would wait until September of 2027 to apply, and basically not have to put that time frame that he was outside of the US on the application.
I must admit that I learned something new right now from you. So if they use re-entry permit, they can argue that they never abandoned their permanent residence in the U.S. Okay.
And you can only do the 4 years 1 day if you've been a permanent resident more than 5 years.
More than 5 years. Yes. Okay, that is great. I did not know that either. All right, let's switch to the other question. Rafa says, my status will expire soon, and my asylum case will still be pending. If I extend my status, I will most likely have only one chance to win my case at USCIS. But if I don't extend my status, my case eventually be heard by the immigration court if USCIS denies it. If I have a strong asylum case, which approach would you recommend from a risk management perspective? So let me understand better. So the asylum office has a new rule now that they are sending affirmative asylum applications to the immigration court if the applicant has filed the asylum application, let's say more than 1 year after entry, or if they have subject to some asylum bans and etc. So since this person is asking this, I am assuming that they applied late. Late because they are concerned about being sent to the immigration court. Am I right? My case could eventually be heard by the immigration court. Are they asking this way because of this new rule? I am not very sure. But if that is the case, we are not sure whether USCIS will take a look at the exceptions, whether there is an exception to the 1 year rule while you file late, or will they automatically send all the late applications to the immigration court? We don't know that for sure. So if that is a concern, and if you want to be fully risk averse, then I would try to extend my status. But I don't know, sometimes if it is just a tourist visa status, it might not be easy to extend it every 6 months. But let's say if it is an E2 investor status, then there might be a better chance, or H1B for the first 3 years, it make much more sense to extend that under this administration. If I were an H1B holder, I would definitely extend that one. But what do you think about this question?
I agree. I mean, if we don't know what the underlying status is, but if it's a status that can be extended, I would definitely try to extend and remain in valid non-immigrant status, as we just discussed with what's going on at the airports and all of that. I would definitely try to extend. Maybe the person is in student visa. I don't know if this person is in F1 status, if they have the option to extend their I-20, especially before the September 15th deadline, that would be advisable.
Yes. I was gonna say something else. If you used affirmative asylum employment authorization document, then you might technically be deemed
Out of the non-immigrant status,
Yes.
If you use the employment authorization from asylum, then if it wasn't even if it was an H-1B, even if you're in student visa, you've technically taken yourself out of that status and you're now in asylum pending status.
Yes, so even if you try to extend, you might not be able to successfully do that. Okay. All right. So Murat Verdiev, I remember his name, asking questions. I am currently on OPT and I've already applied for asylum. Next year, I plan to apply for STEM OPT and I also plan to enter the H-1B lottery. I don't want to fall out of status. Does the fact that I applied for asylum create any risk that my STEM OPT or H-1B could be denied? So again, we just said this, if you use affirmative asylum's EAD, then you technically are deemed that you violated your underlying non-immigrant status. So you might not be able to extend your OPT or switch to H-1B. But I also want to mention one thing for the asylum application. Leila, I'm not sure if you're aware of this, but if asylum office for some reason does not approve the asylum application, they refer it to the immigration court.
Correct.
But if the applicant has another status, another non-immigrant status, then they just deny it. They don't send it to the immigration court. So this is, I think, an important distinction. So if asylum is so important for you, then you might not have the second chance before immigration court if you have an underlying status, because they just deny it and it stops.
So when they deny it, that means they don't, an NTA, a notice to appear, is not issued. You just get a denial, or ultimately you get placed into proceedings.
So you are not be placed in removal proceedings because you have an underlying another non-immigrant status. Yes. Okay. So if they want to have a second chance to explain their asylum before immigration court, the only possibility that they should not have any non-immigrant status. I think it's important to know that. But currently, I heard that I know that they put immigrants into removal proceedings even after I-130 denials, and sometimes after I-131 denials. I even heard about that. But in the past, I see that asylum office denied an application because there was a non-immigrant status active. But I am not sure whether the current administration, they put everyone in removal proceedings. So if they deny asylum, maybe they will do that. No one can know it for sure, in my opinion. Okay, another question. There is a criminal case and arrest warrant against me, but the charges are false. The case was opened only after I reported the people who persecuted me for years. Since the fake case was filed in retaliation for reporting persecution based on my protected ground, would this satisfy the nexus requirement? I guess this would. So I guess the criminal case is filed against this person in their home country, not in the US. So they are planning to apply for asylum in here, and they were asking whether the nexus, like the connection requirement of asylum, there is a protected ground like race, nationality, or religion, political opinion, membership in a particular social group, and there is harm. So there has to be nexus. So yes, in my opinion, this can definitely be argued in an asylum application, and I think you already assumed the answer. Do you have anything else?
Not on this.
Okay. I think we answered this question, so let's go. Frat asks, hello, following the withdrawal of I-130 and subsequent denial of I-485, what is the deportation process like? Is there a court hearing? What happens if the person does not leave the country?
I mean, based on exactly what you were saying just a minute ago, it really depends on whether after the denial the person is placed into proceedings and is served a notice to appear in court or not. Generally, you get 33 days to appeal the decision. And in that case, I believe if you had a genuine case, you should appeal and also refile. Which will prevent being placed into proceedings. Otherwise, based on my understanding, you place into proceedings, and if you don't leave, and if you don't go to court, then you get deported in absentia. Am I correct?
Yes, I think you are right. So under this administration, it is the common practice that after the I-130 and I-485 get denied, then they issue a document called Notice to Appear, and they give you a deportation proceedings date for the master calendar hearing, which is kind of the introduction hearing to the immigration judge. And then they will be asking you whether you have any relief from deportation, such as like asylum, cancellation of removal, or maybe protection under Torture Convention Act, etc. So if you don't have any relief from deportation, they can deport you even in that master calendar hearing now. So you should be prepared for the worst and then try to sort out your possible options here.
And if this is a marriage-based case and it's a genuine case, and the person is married to a U.S. citizen, they can also file the adjustment with the judge, correct?
Yes. So I think the I-130, since the I-130 was withdrawn, so I think the marriage fell apart, maybe.
Okay.
But if there is a new spouse or something, or if you reunited after a brief separation, then it is still possible to file another I-130. And if that is approved, you can file I-485 with the judge if the deportation proceedings has started. Okay. Just one last question. If the USCIS asylum officer finds my testimony credible with no inconsistencies, can they still deny my case just because they don't want to approve it? Or does a denial have to be based on a valid legal reason? I must say that under this administration, we are seeing referral decisions, not approval, referral decisions to the immigration court from asylum office without much explanation. They just say that if they see inconsistencies, they can mention that. But if they don't see inconsistency, and if they just don't want to approve it, they can say that, oh, there is no strong, there was no past persecution, and there is no strong likelihood of future persecution. So they can just deny, refer based on that, and you cannot appeal that decision to anywhere. And you have to try your second chance before immigration court, unfortunately, and they don't go into details, so you cannot object to that decision. So if they don't want to approve it, they can just refer it. Yes, I think it is in their discretion, and you might not have much chance to do something else about it.
Asylum is adjudicated based on discretion?
Basically, yes.
Yeah.
Asylum officer has to, because they don't deny an application, right? Yes. So they just refer it. They don't issue a decision. They just say that, and the asylum referral decision has in bold a sentence saying that this is not a denial of your asylum application. Since there is no denial, you cannot appeal it, right?
Correct.
And technically, even your employment authorization document is still valid because there is no denial and your asylum is still pending.
So it's like a continuance at a different
yes
agency.
Okay, we filed my I-485 EAD and AP on April 6th. And I completed my biometrics on May 6th. I still haven't received my work permit, Based on the cases you are currently handling, are you seeing similar delays? So looks like it's a green card application either based on maybe I-140 or I-130, and this person has applied on April 6th, so it's like 4 months, right?
Correct. Yes.
I think this is common right now. From whatever I see from my own cases, I realize that sometimes it takes for 5 months, and most of the time, if it is a marriage-based case if it is a green card application based on marriage to a U.S. citizen, most of the time green card is adjudicated. For 85 is adjudicated even before I-131 or I-765 EAD application is adjudicated. So you pay the government $260 of filing fee for the employment authorization document application, and then $630 of advance parole application, and they just don't approve it timely. Correct. And that money just goes to waste.
Especially with the I-131s.
Yes.
The processing times are way longer than...
Way longer.
Yeah. Most of the time we get decisions that says, well, we checked, your green card has been approved, so you no longer are entitled to an I-131.
Definitely. So it is needed sometimes if people want to do expedite requests because Correct. They have some emergencies. But generally, I don't recommend filing, especially for AP. But for EAD, this is so critical.
Yes.
I generally recommend filing it. But I mean, in the end, if it is not adjudicated timely, it's just you will lose $260.
Yes.
But if it is adjudicated, you will start making money.
Correct. Yes.
Yeah. So I think this is kind of normal right now. You have to wait, and I hope that your I-485 will be adjudicated soon.
When do you think it's a good time to file a mandamus if his EAD isn't adjudicated?
That is a very good question, in my opinion. So we file EAD delay cases at 3 months now because EAD is so much critical document, because sometimes people are married, they have to pay rents, sometimes there are kids involved, they need to take care of the kids. So without an EAD they don't do much, and generally sometimes they don't even have a social security number. Okay. So it is very critical, and USCIS statistics say that an officer adjudicates the employment authorization document application in just 12 minutes. So instead of fighting with the lawsuit, they generally adjudicate the employment authorization document. That's it. So I would definitely recommend, if this is critical for them, I'd recommend filing a mandamus lawsuit after 3 months. All right, another question. My fiancée has a B1, B2 tourist visa. If she enters the US as a tourist and our plans change and we get married spontaneously, but 90 days after entry, is this a problem for adjustment of status? So if your fiancé has a genuine intent of staying here temporarily while using the tourist visa during the entry, and if indeed the plans changed afterwards, I would recommend you to collect as much as possible to show the intent change even after 90 days. So for my clients, I have not encountered any problem so far, but I heard that one immigration attorney was on YouTube saying that even after 90 days, they questioned his client regarding the intent very thoroughly. So what do you recommend here?
I agree with exactly what you just said. My only concern over here is that he wrote my fiancé. So if that's the case, I would be careful with that, because when this person enters the US and they ask the purpose for the visit, and if they don't declare that I'm here to see my fiancé, that might also bring misrepresentation upon if they apply for an adjustment later.
Okay, so if they are asked about the purpose of the visit, they should say it, and then if the plan has changed in the US for sure, then it is still possible.
Yes, and also know that if when you're entering the U.S., you're saying that I'm here to visit my fiancée.
They might take you to secondary inspection.
Yes.
And then question you thoroughly whether, and they can even look at the, maybe your luggages, saying
Yes.
that, or if they are extensive, they can think that your intent is.
So if that's the case, coming to the U.S., I would have the documents to show why you're going to go back. Make sure, maybe have a letter from your employer that you're still employed, you're on leave, and any other document that would support that you will be going back.
Return tickets, for example.
Well, return ticket is a requirement for B1, B2. If you don't have that, that's going to be very problematic. But besides that, any ties that they would have to their home country, I would also have evidence of that.
Definitely. Emre Doğan is asking, if an I-130 petition for a spouse filed inside the US has been pending for 3 years, and following a Mandamus lawsuit, the petition is denied, can the Mandamus lawsuit be amended into an APA lawsuit to have the decision overturned? We need to take a look at the I-130 denial notice. Generally, I think I never did an APA unlawful denial here, but if they make factual mistakes, that might be possible. But we definitely need to see the I-130 denial. I believe, is I-130 a discretionary decision like I-485 or not?
I don't believe an I-130 is discretionary. Yes.
Okay. So there might be a good chance of APA unlawful denial lawsuit, but we need to take a look. So if you do believe that your marriage has always been genuine and the allegations in the denial notice are not accurate, or they don't apply the correct standard to make that decision, it might be a possibility. And most of the time when we do file unlawful denial cases, we see that USCIS reopens the case and then issue an RFE or NOIT to give you another chance, and then they try to moot out the federal court lawsuit, saying that we did take action and it is no longer denied, so the lawsuit is kind of purposeless. Yes. Do you have anything else on this one?
No, I mean, I feel like if it's a recent denial, maybe a motion to reopen or motion to reconsider might also be an option if they have the evidence that was required, and they can basically argue that there's new evidence or there was evidence on file that USCIS did not pay attention to.
Yeah, so what you suggest is that in the alternative, instead of going to the federal court directly, they can do I-290B with USCIS Administrative Appeals Office and try their chances there. And if the case is not reopened, they can still go to federal court. But I just want to mention that going through the Administrative Appeals Office by filing I-290B is not a requirement for unlawful denial federal court lawsuit. So yes.
And it is time consuming, the appeals, the motions to reopen, motion to reconsider, and maybe depending on the facts of the case, maybe it does make sense to go through the federal
court litigation. Yes. But the federal court litigation is obviously would be, I think, much more expensive than the 290B, in my opinion, regarding legal fees based on what attorneys charge, right?
Correct.
All right, I think we are done with the questions. Thank you, everyone, for attending our another live. We will be here next week on August 11 at 2 p.m. New York time. And thank you, Leyla, for attending again.
Happy to be here.
Thank you. Bye-bye.
Bye-bye.